Hey everyone, it's Marco Brown. Hope you're having a good Monday. I wanted to come talk to you about something called the right of first refusal that we have here in Utah and just kind of go over what it is, the pros and the cons, and why we don't usually use it in our divorce documents. So the idea of the right of first refusal is that kids are better off spending time with their parents than they are spending time in what's called surrogate care. I'm going to talk with you about what surrogate care means, but really it means non-parental care. So that's what the right of first refusal is. And what we normally do, the way we normally write a clause about the right of first refusal, is if a parent can't be with a kid on his or her parent time for more than 3 or 4 hours, then that parent has to give the other parent the opportunity to come watch the children. So say you're going to work for 8 hours and the other parent is home. If you had a right of first refusal, it's 4 hours, you would need to tell the other parent, hey, look, I'm going to be at work, you can come get the kids. And then the other parent would come, get the kids, take them back to their house, and then return them when you got back from work. So this brings up an interesting question that comes up all the time. Who does the transportation for the right of first refusal? It's the person who wants to have the kids. So again, if it's in that situation where the parent is going to work, you call up your ex and you say, hey, look, I'm going to work here. And that parent, the ex, has to come get the children and then take the children back to the house. So they have to provide all of the transportation. In some of these situations, we have people, the ex will say, well, you're the one going to work, so you need to transport the kids to me and then come get the kids at the end of work. No, that's not how this functions at all. If you want to exercise the right of first refusal, then you go get the kids and you take the kids back when the other parent is able to have them again. That's just how this works. Okay, so normally right of first refusal is between 3 and 4 hours. I don't like that at all. I think that's way too short a period of time. If you go on a date, it's going to be 3 hours, right? So every time you go on a date, you have to tell your ex about it and offer the kids to the ex. So not a good way to go about it. Usually, if we do the right of first refusal at all, really what we're doing is overnight. So if you're going to go out of town or you're going to be gone overnight and leave the kids with somebody else, that's not like, an overnight with the grandparents or something, but you're actually going out of town and leaving the kids, then at that point you would need to tell your ex about it and give your ex the opportunity to have the children with them for the right of first refusal. I think overnight is much, much better than the 3 or 4 hours. Just the longer you can space it out, the better, because I don't really like or believe in the right of first refusal anyway. So this brings up a question, what is surrogate care? Like I said before, surrogate care is essentially non-parental care. So it's anybody that isn't a parent watching the kids. So daycare, if you leave your kids with like grandma and grandpa while you go to work, any of these things be considered surrogate care. So one of the things that comes up all the time with the right of first refusal is fiancés and new spouses. Are fiancés considered surrogate care and are new spouses considered surrogate care? And it depends on how you write the language in your divorce decree. Fiancés are almost always considered surrogate care because they're not spouses. Boyfriends, fiancés, you can drop them at any time, so they don't really consider them parental care. They're going to get considered surrogate care unless you write it in that your fiancé is parental care. So that's one thing to keep in mind. New spouses, on the other hand, they're almost always considered parental care unless the right of first refusal is written in such a way that it only applies to you as the parent. But really, it's any new spouse is going to be considered parental care unless it's written in some like super funky way. So fiancés, yeah, really not. New spouses, yeah. Now, why don't we use the right of first refusal here? Really because it just allows people to micromanage each other. So you divorce your ex for a reason. You don't want to be around that person. And then you enter into an agreement where you have to let that person know when you're going to be gone from the kids every time that you're gone for 3 or 4 hours. It just leads to complete and total micromanaging of of your ex, right? Or of yourself by your ex. And you do not want that. So just for that alone, I think the right of first refusal is just not really worth it in 99% of the cases. You have to actually tell your ex what your work schedule is, what your school schedule is, what your dating schedule is. Again, it just goes to the micromanagement. So no. And then you go back to court on the right of first refusal all the time. There are so many motions for contempt that are given to the court on the right of first refusal. And the right of first refusal is really, really difficult to prove because, what do you do? How do you prove it? Even for lawyers, it's super difficult. So if you're trying to do it on your own, you're simply not proving it at all. And I can tell you the commissioners and the judges hate the right of first refusal because they have to hear all these motions for contempt and nobody can prove anything, and they just get up there and waste the court's time and yell at each other. So even the courts don't like the right of first refusal at all for the most part. Now, when is the right of first refusal appropriate? When is it good to use? The only time that we ever really use it is when there are serious safety concerns regarding the kids. So maybe your ex is really a serious safety concern and leaves and then puts the kids with somebody who is a safety concern, right? So he's got a brother who's on the sex offender registry list, but the brother is the one who gives daycare when your ex is out. I've had these cases before. This stuff happens. So in those sorts of situations, yes, the right of first refusal is totally and completely appropriate when there are major safety concerns for the kids. Other than that, though, I think it's a big waste of time. I think it's a big waste of money. And it is definitely a way for people to micromanage each other and just keep the stress of the divorce going. I mean, you're essentially reliving your divorce every time you're having these fights over the right of first refusal. And people who are going through divorce just don't need that. They need to be able to move on. So all in all, I say, unless it's a real safety concern, you just don't do the right of first refusal at all. So if you have any questions about the right of first refusal, drop it in the comments below, even after this. And I'm not going to be live, but I'll check the comments and I'll answer anything I can. If you have any questions about anything else Utah divorce related, pop into the comments below and I'll do another live stream and answer the questions. So thanks everybody. Hope you have a good Monday.